Good morning and welcome to day 3. The other 2 days, you've had the opportunity to hear and discuss questions regarding how to do it right. I think of day 3 as the day where things maybe have gone a little awry. And so we will be talking with enforcement, both in the government and defense bar. We'll be talking about enforcement issues. In the afternoon, after our lunch break, we'll be expanding out and talking about civil litigation, internal investigations, and of course the all-important ethics panel. But to start us off this morning, we're fortunate to have Grewal with us, the Director of the Division of Enforcement, who needs virtually no introduction other than that. But prior to that, Gurbir, you were the Attorney General in the state of New Jersey, and prior to that, you had, I would describe it as various roles within the Department of Justice and U.S. Attorney's offices. Is that a fair?
Fair. I was also a county prosecutor, believe it or not.
Prosecutor.
Yeah, in between.
Okay,
so, yeah.
okay. So various, but prosecutorial roles.
Yeah, the usual career path to enforcement director.
There you go. Yeah. Certainly in the last decade or so, absolutely. So thank you so much for being here with us. So you recently finished your first year as division director. I think it was August 2021 you started-ish, around that time.
That's right.
Right, and so first full year, you got to go through the end of the fiscal year rush and everything. So what were some of the highlights from the past year that you wanted to focus on for this crew?
Sure. I mean, has it only been one fiscal year? Because it feels like a number of years. Maybe it's like dog years. No, thank you for having me, and let me start with the usual disclaimer that my views this morning are my own and don't reflect the views of the commission, the commissioners, or the staff. I think I'll answer that question by going back to what I said when I started in this role, both internally and externally. And the message that I was able to give to the defense bar and the office early on at SEC Speaks was that, you know, the animating principle for us needs to be to restore public trust and confidence in our markets. Because I shared my experiences as Attorney General, where I realized through those meetings that I had across the country and through my state that large segments of our population had lost trust and confidence in government institutions, as well as financial institutions. So I thought it was important for us in the division through our work to help restore that trust. Because when that trust doesn't exist, that hurts all of us who are playing by the rules. If you think about it for a second, if people don't have trust and confidence in the markets, they're not going to invest their hard-earned money. And that hurts everybody who's working in this space. And the reason for that decline in trust, there's no single cause, but in my mind and from my experience and from what I've seen, some of it is born out of this perception, or maybe misperception, that there's two sets of rules out there, one for the big and powerful, and another for everyone else, and that people are getting a pass for misconduct. Or it's, you know, heightened by the fact that people might hear a news story on day one and not see any resolution until 2 years later or 3 years later, and in that intervening period, they're left to wonder, you know, where's the accountability? So when I spoke both to the staff and to the defense bar, the points I made is that we're going to work with a sense of purpose to regain that trust, and we're going to do that by doing 3 things. One is being proactive in our enforcement efforts, working with a sense of urgency to address new and emerging risks. 2, we're going to really focus on remedies. We want to make sure that penalties are having the deterrent effect that they should, and that they're not simply priced in as a cost of doing business. We want to dust off the rest of our toolkit, use admissions where appropriate, and undertakings as appropriate to really help reinstill confidence in the markets, and also to encourage good behavior. And the third thing that I talked about, and relevant to this room, is that we can't do it alone. We need to create a culture of proactive compliance. We can't be everywhere. That's why we need you in this room. We need the compliance professionals. We need the gatekeepers to do their jobs. And so if you look at those 3 buckets, those three principles that I just highlighted, by any account, I think the last fiscal year was a success for the SEC Enforcement Division. If you look at the numbers, which is a metric by which we're measured, we brought more enforcement actions last year than the prior year. If you look at the penalties and disgorgement, the numbers will come in when we announce them at around $6.4 billion. The chair highlighted this, $4.2 billion of which will be penalties, which is the highest in the SEC's history. That's not something that we're proud of, but we think it was important to institute those penalties to encourage better behavior. You know, it's not something we want to go out and do each and every year, but when we want people to play within the chalk lines, when we want to make sure that that deterrent message is being sent, those penalties are important, as is disgorgement. And so that's one measure, but if you look at cases, Joan, in each of those categories, when you look at proactive enforcement, we were, addressing emerging risks in the private fund space and working with a sense of purpose in the Archegos matter that we brought within a matter of months of those news reports coming out. I think it was 11 or 12 months from start to finish in that case. If you look at Allianz in the private fund space, Infinity Q, all cases that we worked with a sense of urgency. If you look at emerging risk areas, we brought a number of ESG actions. We brought the BlockFi resolution in the crypto lending space. That's sort of that category of proactive enforcement. If you look at robust remedies, I could point you to the books and records cases. They brought in over $1 billion in penalties because we thought it was so important to highlight the importance of record-keeping requirements, which were being flouted regularly. You know, it's one thing for everyone to have policies. It's another thing to implement them. So that's why those cases were so important. And in the compliance space, we had an emphasis on gatekeepers. Ernst & Young, which we can get into later, was a case that highlights that commitment to making sure that we encourage gatekeepers to be part of this effort, that collective effort I spoke about a moment ago. And Melissa's here, her group worked on that matter and the Deloitte China matter, another important gatekeeper case, and I'm sure she'll get into it during her part of the discussion. So I think, if you look at the metrics, the numbers, if you look at the types of cases we brought, the urgency with which we worked, I think we're well on our way, and the staff has really delivered on working to promote public trust and confidence in our markets.
Very, sometimes people will look at, I call them the text message cases, but you probably call them books and records cases.
Off-channel communications,
Off-channel, yeah. And some people would say, wow, those penalties were huge for just a record-keeping requirement. But what you're saying is you view that as fundamentally important.
I do, because, maybe it's the county prosecutor in me, maybe it's the federal prosecutor in me, maybe it's now the securities regulator in me. Those requirements are fundamental. We need to be able to see what happened. We need to be able to go back and unpack the records to see, after there's an allegation of misconduct, who did what, who said what to whom, what transpired. And when people are deliberately engaging in communications to evade the record-keeping requirements at their firms, that's problematic. And so this was not, in our experience in these cases, something that we attributed to the pandemic and this virtual environment. It predated that. It was sort of a casualness to the way people were communicating, and that undermines our ability as regulators to investigate matters, and that frustrates the Commission's purpose. And I think that's really why the penalties were where they were, the undertakings were where they were, the fact that we required admissions. The previous high penalties in books and records matters of this type were in the $20 million range, I believe, a number of years ago. And clearly, those penalties did not have the deterrent effect that they should. And we hope through these set of cases that folks will start to play within the chalk lines and better behavior will follow.
And so you were talking about what you brought, obviously very impressive from the prior year, but looking ahead, will your focus be the same, or will it be a different focus or an additional focus?
I think we're going to look at the same three areas. We're going to emphasize proactive enforcement. We're going to have a particular focus on remedies. We're going to continue to encourage a culture of compliance. And I think particularly now, I think Warren Buffett said, when the tide goes out, you see who's been swimming with their shorts on. I think the corollary to that is that a rising tide hides a lot of fraud. And we think with the way things are trending right now, We need to be particularly vigilant, whether it's in the private fund space where there's a lot of opacity, and we've seen recently between Allianz, Archegos, Infinity Q, and other matters, a lot of fraud. And so that's an area where we'll be focused. We'll continue to be focused in areas that are important to investors, whether it's the crypto space, ESG, and related spaces. We need to be on top of issues that are important to investors and to make sure that issuers are truthful in their disclosures, and if you're marketing funds in a certain way, that you're doing so adhering to the duties that apply to you. And so, I think you could expect more of the same.
So you mentioned issuers, and of course, a lot of the people in the audience, both here and online, are in the issuer space, and a lot in-house compliance and legal. Is there any particular messages that you want to pass along to that group?
Yeah, I think, first of all, this is a great opportunity because, I would much rather be in a place where we come back with no penalties and no enforcement actions. Yeah, and that's a pipe dream. I would love to be in a situation where our folks are investigating matters and coming out and saying everyone's doing their jobs and there are no issues, right? But we're not there yet. My message to folks who are in-house, who are at issuers, who are in compliance departments is that we need your help. We need your help in that trust-building exercise that I mentioned a moment ago. We need you to be engaged in your businesses. We need you to really understand your businesses, the risks in your businesses. We need you to be leaders in your businesses. We need you to, if you don't understand a particular business line, gain the knowledge to understand that business line. So, really want engaged professionals out there. We want people to educate themselves. Educate yourselves to emerging risk areas. I like to say if there's one thing, although some might criticize us for not offering clarity in certain spaces, but if there's one thing that we're not guilty of, it's the element of surprise. Where we're looking, whether it's through exams, risk alerts, or through enforcement actions. If you're in-house, if you're in a compliance department, read our orders. We're trying to be more intentional in our orders in messaging out the types of behaviors that are troubling to us, but also at the same time, the type of conduct that we're rewarding, what cooperation truly means. So, be engaged, educate yourselves. And then I think all of the compliance professionals in this room and online just also need to execute. Because if you look at the books and records cases as an example, those policies were there at a lot of those broker-dealers. Mm-hmm. What the policies required, what people should be trained on, but there wasn't implementation. There wasn't the type of follow-through that needs to be there. And so I think that's where a lot of folks have fallen short, is in the implementation piece. So if you do those three things, the engagement, the education, and the execution, I think we'll be in a better place, because the violations we're seeing really are where that failure on implementation happens. I could give you a couple of other examples. In the FCPA space, we had a matter with WPP, I think, last year, a large advertising concern, which was acquiring a lot of different business lines. Mm-hmm. It didn't really have a compliance department. How does that happen? The world's largest advertiser is integrating all these business lines in all parts of the world where there's high risks of corruption, and doesn't really even have a compliance department. That's just basic. We had a recent resolution with Tupperware where they were integrating different businesses. They had a business that they acquired in Mexico, and there wasn't that deep dive into what are the risks in this business, integrating that business appropriately, and having the right policies in place. And that was a recent resolution that folks should look at as to the types of failures we're seeing in that execution piece.
That's great, and certainly clearly stated. So that's very helpful advice. Thank you, Gurbir. You mentioned cooperation when you were talking about it, and about the transparency. Obviously, it's always an important consideration when something has gone awry. And I've noticed that there have been some cases where you tried to highlight the credit for the cooperation. What should be a reasonable expectation for credit for cooperation? I think some people are hoping the whole matter will go away. Is that reasonable, or let's set the expectations here?
On the continuum, I would put that expectation on the unreasonable side. I think you're right. The commission's trying to be more intentional in our public statements where we're speaking about cooperation. The behaviors that earn cooperation credit have been known to people in this room for over 20 years out of Seaboard. It's the 4 pillars that we were talking about earlier. It's the self-policing, it's the self-reporting, it's the remediation, and it's the cooperation in any enforcement investigation. So I think those are sort of the core principles we look at. We have, in recent orders, made clear, I think Kronos was last month, there was a revenue recognition case where we talked about the self-reporting, where we talked about the cooperation, and that behavior earned a 0 penalty for the firm in that particular case. So we're being much more intentional. I think, again, going back to the 3 principles I laid out for in-house folks, that's part of the education. Stay apprised of our orders in these cases because you'll see the benefits of cooperation when you're making that assessment, even for folks who are counseling clients. I know it's not an easy conversation when you're trying to convince a client to go in and bare your soul to the enforcement division or other regulators, but it really puts you in a better position than trying to hope a matter is not discovered or that side of the continuum that things would go away. You're in a much better bargaining position with us with self-reporting coming in and working with us.
Because there is that discussion, and sometimes people do wonder, does it really pay to go in? What if you missed the first 2 pillars? You haven't found the problem. You didn't self-report. It was in an article in a major publication or enforcement through market surveillance found the issue. Is it still worth cooperating, remediating?
Absolutely it is. Again, you're in a better position when you're working with us when it comes to the resolutions we're going to recommend to the commission. I think I could pull a recent example. I think it was in August, we had a resolution with Surgalign. This was a revenue recognition case, I believe, and it was something that we discovered through our EPS initiative. And so we went to the firm, identified the issue. It wasn't self-policing, it wasn't self-reporting, but once we went to them, they did a full-on internal investigation. They dug into the issues. They identified additional issues and areas of concern for us and came in. They didn't have a 0 penalty resolution in that particular case, but if you look at the other cases in that EPS initiative, the penalty recommendation was far lower than similar cases. And so I think that's a recent example of how even if you miss out on the self-policing, even if you miss out on the self-reporting, you're in a much better position with us if you come in and work with us and provide the type of cooperation that we sort of highlight in these orders. I will say, we quite often have that conversation where folks come in and ask for cooperation credit, and the only thing they point to is that we provided you documents in a timely manner. But that's like the bare minimum, right? You're required to do that. And so that's, on the other end of the spectrum, the behavior that doesn't really entitle you to...
The mistakes.
The mistakes, yeah. And so, that would be my advice, that even if you miss out on the self-reporting, there's still a better place. You'll still be in a better place if you come in and work with us.
Well, if Melissa's going to talk about the EY settlement, maybe we'll skip over that for now. One thing in terms of resolving cases, so we've talked about cooperation, the investigation stage. What about there was some discussion regarding 304 clawbacks at SEC Speaks, and I think that people had always believed that it's true. It does say that they owe this, the CEO and CFO, and this is the Sarbanes-Oxley clawbacks that we're talking about, not what may come with the Dodd-Frank clawbacks. But what is the expectation there? Because sometimes it's not easy to calculate what all is included.
Yeah, the 304, the rule really just plainly states that you're required to disgorge these profits if, for the period after the financial statement that's corrected, if it's a result, if that correction is, if that restatement is a result of misconduct, and it doesn't have to be a culpable CEO or CFO. So it's pretty plain that the incentive-based comp, other comp in that period after the financial statement that's reissued is disgorgeable and needs to be returned. And so I think that's, if you've seen it in recent enforcement actions, we're enforcing the letter of SOX 304. Sam spoke about this at SEC Speaks. It doesn't require a culpable CEO or CFO. They don't have to be involved in the misconduct, and we have brought recent standalone 304 actions, and I think that's something you'll see more of from this commission. And I think a related point, quite often in the past, the clawback has been limited to often what people term as the fraud delta, that portion of the compensation that was inflated due to the misstatement. The rule doesn't limit it to the fraud delta, and so we are going to seek in the appropriate cases, and again, every case is based on its own facts and circumstances, but the entirety of the incentive-based comp that is subject to the clawback, not just the fraud delta. That's not to say if an issuer on its own starts that process and again, is being proactive, that we won't have room for negotiation in that particular situation, but we're entitled to more than the fraud delta. And so I think that's an important point to share with this particular audience.
Yeah, no, that is very helpful to know. There's been a lot of talk the first 2 days of this conference about ESG. It's on top of mind, I think, for every issuer, and of course beyond, but certainly in the issuer community. From an enforcement perspective, you mentioned ESG when you were, I mean, this is the lightning round on enforcement this morning, but you mentioned ESG. Any thoughts? You did mention a case in that space, but can we expect more? There's the task force. Is this still an important area? Has the division moved on, or what can you tell us?
Sure. I mean, it is a very important area. I think you've seen that in our enforcement actions in this space. You've seen that in the task force that Commissioner Lee set up when she was the acting chair. It's an important area for us because it's important for investors. If you look at recent surveys, the thing that directors are often asked about the most is the issuer's ESG policies and their ESG practices. So it remains important on the issuer side. It's important on the fund side as we see more and more ESG branded funds out there in the marketplace. And so we will be policing misconduct in this space as we have. And there's also a lot of talk about rulemaking. I think you had some conversation on Tuesday with the chair on this issue, or Wednesday. I'm still jet lagged.
We're good.
But there was a question, I think, posed to the chair on the rulemaking. So, it's important to the commission, it's important to issuers, it's important to funds, it's important to investors. And we're not waiting for new rules here. What we're doing is we're using, our existing rule set to hold issuers accountable. If they're going to speak on climate issues, if they're going to speak on ESG issues, they need to make sure that they're speaking truthfully. And if they're not, and misstatements are material, then we'll bring action. And we did that in Vale. I think that was this fiscal year as well. Vale was an issuer and made false statements in its ESG disclosures around the safety of certain of its dams. And unfortunately, one of those dams collapsed and resulted in the death of 270 people. And that's a litigated action that we've brought against that particular issuer. On the fund side, if a fund is going to say that it's scoring certain investments based on a certain ESG criteria, it needs to be truthful. And we brought an action recently against BNY Mellon for not abiding by the ESG scoring practices in that particular case. And again, none of this is new. You call it ESG today. A decade ago, it was socially responsible investing, and we brought cases at that point. We had the Pax World case at that point. Again, because a fund misstated what it was doing related to its investment practices. And so you will see more of that because it's important to investors, and we see a lot of activity in this space, and we'll continue to be vigilant in this space as well.
So we certainly don't need to have new rules to see enforcement actions in this area.
Well, we have enforcement actions. I think the rules will help us see some consistency in the disclosures, and so I'll leave the rulemaking at that.
Yeah, yeah. Turning very briefly to insider trading, there was the Panama case that alleged violations of what everyone calls shadow trading. So it wasn't trading in the securities of that particular issuer. It certainly garnered a lot of attention. And many of the folks here, especially the in-house legal and compliance, who have to clear trades, what can you, is this something that's going to continue to be an area of interest, or sometimes you have unusual cases that are just based on the facts, but what can you tell us in terms of, is this a new trend? What should in-house folks, especially those that have to clear trades, what should they be focused on?
So the first thing I'll say about Panama, which was, I think, in the fall of last year, I wouldn't call it shadow trading. I would just call it insider trading, because I think like every other insider trading case, it's about information asymmetries. And if you look at the facts in Panama, which I have to be a little bit careful about because it's a litigated case right now, Panama worked at a biopharmaceutical company. And in his role at that company, received information that his company was going to be acquired. And based on that information, he traded in the stock of a competitor in a very narrow industry segment. He traded out-of-the-money options in that particular case, earned a significant sum of money. Panawat also signed a confidentiality agreement and an insider trading agreement with his firm, which said that through his role, he would have access to material non-public information, confidential information about mergers and other related business activity. And that information could not be used to trade in his own firm's stock as well as in any other stock. So I don't think any of that sort of is novel, right? It's not new or novel that that an employee at a pharmaceutical company might get access to confidential information about regulatory activity or about merger activity. It's not novel that that confidential information could be material to multiple issuers. It's not novel that you can't misappropriate information from your employer. And so I think all of that is well settled. And so so to call it shadow trading, I sort of brush back at that. To me, that's sort of classical insider trading. Not classical, I mean, these are loaded terms, but it's insider trading. And what I will also say is that they had policies, right? They had policies that spoke to this possibility. And so the advice to the folks in this room, again, it goes back to that. The 3 points I made is on engagement with your business lines. It's educating yourselves about the actions we're bringing, exam alerts, actions like Panawat, and then implementation and execution, making sure that your policies are speaking to these issues that exist in your businesses, and making sure that you're keeping on top of these issues with your employees through training, and that you're monitoring for these type of possibilities. Because I don't think it's an outlier. I think you'll see this, especially in businesses and industries that are really segmented like this particular space was.
I've heard you say now a couple of times, don't just have policies. So check the box mentality is a problem. And you can have perfect, gold standard policies, but the implementation is key.
It's absolutely key. That's where we see a lot of people fail, and that's what, you'll see it in enforcement actions. I could reference the McKinsey action we brought against MIO. It was a 204 Cap A case where, they had the policies, but they weren't really being implemented. And so we always see that breakdown in the implementation piece. And so I think that's what folks should really be focused in on. It's not enough to have a check-the-box policy. It's really important to execute and implement and make sure you're abiding by those policies.
So Gurbir, we have about 30 seconds here. You get to have the last word. You've said a lot this morning and packed a lot into a half hour, but is there anything more that you'd like to add?
You know, I think, again, I want to underscore that this is really a shared endeavor. I really, truly believe that this trust-building exercise that we're engaged in, that I think we're engaged in at the Commission and the Enforcement Division to restore trust in our markets, it's a shared undertaking, and that all of us will benefit from compliance and creating this culture of compliance. And it's going to lead to better outcomes for your businesses, and hopefully it'll put us out of business.
Probably not, but thank you for that thought.
Yeah.
So thank you so much for taking the time this morning, especially after having just come back from London.
Yep,
So
no, my
thank you
pleasure.
very
Thanks
much.
for having me.
And so we do not have a break. The next panel will come up. Okay, thank you so much.
Thank you very much. That was really great.